Hi, this is Attorney Mike Grave. I'm coming to you from Chicago as usual, and today I have the lovely and gracious Suzanne Kelleher.
Aww. Thank you, Michael.
She is my probate guru. And this particular case, I told you guys about this in the last video. It gets into probate. So you law nerds are going to go crazy. You're going to love this.
It's the exciting stuff.
How long have you known me, Suzanne?
A long time.
I've never called you Suzanne in my life.
I know. You know my secret. You might know my secret name. Yeah, long time, Mike.
Yeah. Well, we went to law school together, and she when we were chatting just before this, she's threatened to start telling stories. So what we're going to do is we're going to get started.
Good thinking. Save yourself.
Good morning, Mary. You better approach the witness stand here, and then once you get there, I will swear you in. So please, come right around this way and step into the well there, and then once you get there, if you could raise your right hand and face me, please. Do you promise the testimony I'm about to provide will be the truth, the whole truth, and nothing but the truth under penalty of perjury? I do. Thank you. Mr. Stady?
Thank you, ma'am. Please state and spell your name.
Robin Renee Renwick, R-E-N-R-E-N-A-E.
Thank you, Super Secret Squirrel.
Okay, and I think the court wants us, we're gonna keep our masks on for the most part.
Yes.
Do you know a person by the name of Roger Hillygus?
Yes,
And how do you know him?
it's my brother.
Do you know Susan Hillygus?
Yes, that's my mother.
I'm gonna talk to you about how your mother came to be at the Stone Valley care home in.
All right. So the defendant in the case is Roger Hillygus. We talked about this for just a second beforehand. He's charged with kidnapping his mother. This is his sister. Just a little recap for all involved.
Leading up to this case, can you please tell us how that happened?
I don't know how far back you want me to go, but in 2016, in the spring of 2016, there was a court petition for me to be co-guardian with Fiduciary Services of Nevada, and that was granted by the court. So at that point, I was placed in the position to be co-guardian.
And this resulted out of
Your Honor, objection. I'll withdraw it.
The hell's a co-guardian?
Well, she doesn't say who she was co-guardian with, but that just means she's one of two, and that gives her the power to make the decisions for mom. So mom was declared
My
disabled.
first question is, when you're in that scenario, if you're co-guardians, does either one have veto power, or does either one get to make a choice?
At least where I'm from, it means they have to be in unison. So one can't do anything without the other. And
so they have to agree.
Yeah. Do we know who the co-guardian was?
I don't.
Yeah. So it's not the brother though, right? Or do we know?
That's my question as well, but I don't know.
Yeah. So,
but right there, if they have to agree already, he doesn't have authority without her.
Right.
I think he gets revoked or something. We'll see more as she testifies.
Plus, the court has to oversee it, whatever she does.
out of a long history of litigation involving yourself and your brother.
Your Honor, that's a leading question. I object.
Well, what answer does it obviously call for?
The presumption is that there was litigation that led to the guardianship. That's not true.
Oh, that is true.
Well,
Just wait till the questions are posted. You may miss Renwick.
Thank you, Daylight.
So it's not.
I think it can certainly be asked as an open-ended question. Go ahead, Mr. Stady.
How was it that it came to be that the court issued an order directing you to be the co-guardian?
In 2014, all the legal aspect of this began with my brother was the trustee of the Hillygus Family Trust. And then in
All right, I'm sorry. Help me out. What is trustee of the family trust as opposed to guardian? For
So
everybody.
mom and dad at some point during their lives went to a lawyer and said, put together a trust for us and we can pick who we want to be our trustee when we're not able to do it anymore. They must have picked the brother. And so when mom and dad become incapacitated or pass away, then this person steps in and manages the finances. So brother must have had that nomination under a trust document that mom had created in her lifetime.
Okay, but as trustee, you wouldn't have. They didn't need guardianship at that point. This is sort of perspective, looking at the future.
So, right, at that point, mom and dad must have been competent. It was long before mom had her disability come about. So she must have been competent when she created that trust.
Okay.
2015, he was removed as trustee of the Hillygus Family Trust. And I was in then 16, I was put in position as the co-guardian of my mother. And at that point, Fiduciary Services was my co-guardian and they were the trustee of the Hillygus Family Trust.
And in the meantime, okay, and so what was the status of the guardianship leading up to this case in August of 2019?
Your Honor, I'm going to object on the best evidence rule. There needs to be legal documents presented to this court of a certified nature to support.
I move in Exhibits A through D, certified copies of.
Oh, I haven't seen those. When did you get
Your counsel in those.
I am aware of that, but I'm entitled.
This is good. So I thought about cutting this out, but then it gets really chippy and it's just fun. But as soon as they started getting into the best evidence rule, I'm like, I don't want to describe this to my viewers.
Yeah, it's too much. Yeah.
But since it gets chippy, I held it in there. You'll see, it's kind of fun.
To see documents you're introducing to evidence.
And counsel, let's just take this step by step. If Mr. Steggy's proffering something into evidence, and he can certainly reference what the state's exhibits numbers are.
Actually, I'm not moving it to that bin yet. And I respond, best evidence rule.
If he has the documents and he intends to introduce them, that solves my objection.
Counsel, I've asked you before, please do not speak over the top of each other. I cannot hear what either party is saying when you're both speaking at the same time.
Sorry, Your Honor.
I believe Mr. Steggy's question was about this witness's personal knowledge. I will allow her to answer that based on her personal knowledge at this point.
I think she's already given, well, in the meantime, how was that your mother, sort of in the legal context, came to be living in the home?
When Roger was removed in December of 2015 as a trustee and guardian of my mother by the courts, they removed him. At that point, I was put in the position as temporary trustee of the Hillygus Family Trust and temporary guardian of my mother. My mother was still living in her house at that point, and Roger was living at the house with her. The judge allowed Roger to stay as my mother's caregiver at that time, although I was the temporary guardian. This was awaiting the hearing that we went to in spring of 2016. At that time, when Roger was the caregiver, my mom had a problem with her heart and she was admitted to the hospital in January of 2016. And my brother was the caregiver and I was the co-guardian. So at that point, I was very involved in all of the proceedings at the hospital. So when it was time to pick my mom up.
Are you following this? I still don't get this. He's saying he was once a trustee, then some motion was filed or something to remove him. So they go to court. Probate judge says, all right, you're out. Appoints her temporary.
Mm-hmm.
But then she says co-guardian again.
Yeah. So The only reason the court would remove him as a trustee is if they find he was doing something improper. And so something went on there. When you remove someone, you've got to replace them. So they replace him with sister. Guardian is a different animal in that you just need somebody to make medical decisions for mom. So that's where the guardian appointment comes into play. So the trustees handling the finances, the guardians handling the medical decisions. And I assume the court was hearing all this, and for some reason it wasn't brother, and they put sister in his place.
For those of you who are joining late, Sue is my probate guru. She's an attorney in Chicago. We've been doing business together for years. We went to law school together. She's got stories that she's not going to tell. And let's carry on. Oh, and thank you, Patrick Leday. I appreciate it.
From the hospital because she had a pacemaker surgery completed and put in. When it was time to pick her up, I communicated with Roger through Family Wizard, and I said, Mom will be ready to be picked up from the hospital at this time. And his response back was, and he's being paid as caregiver. He's living in my mom's house, and he is being paid a monthly amount to care for my mom, even though at that point I was the guardian.
That's per the proceedings?
Yeah.
Okay.
Roger refused to come and pick my mom up from the hospital, and he said, you take her home with you. So at that point, I took her back to my house, and she continued to live there with me until the spring of 2016 when we had the next hearing. And I was, at that point, no longer the temporary guardian of Susan Hillygus. I became the permanent co-guardian of Susan Hillygus. And at that point, I asked fiduciary services to take the role of being the trustee and co-guardian as a private company.
Okay. And
Okay, so with fiduciary services, did I get that right?
Yeah, that's what it sounded like. She mentioned it's a private company, which there's a lot of those out there who will do the work of managing mom, her finances, and her medical and residential decisions for a family. Sometimes that happens in families where they don't get along, and so they pick that neutral party to come in and take over.
See, that's why you're here. I would have never known that in a million years.
That's what it sounds like. They're not seeing eye to eye, so they bring in the outsider to take over.
That makes sense. So it's really her, but it's her with this company that they brought in.
Right.
Okay.
what was the status of the guardianship trustee question leading up to the date that the incident in this case occurred?
So at the time that the incident occurred in August of 19 at Stone Valley, I was the co-guardian of Susan Hillygus, my mother.
And
Fiduciary Services was also a co-guardian with me.
And as a result, you, the two of you, the co-guardians, were responsible for what decisions?
We were responsible, as co-guardian, we were responsible for all of my mom's healthcare, safety, medical. We were in charge of all the decisions for my mother.
And from how was it, or was there some sort of legal action that occurred to that resulted in your mother? You said she had been living with you to living at Stone Valley. How did that occur?
The courts, we petitioned the court and asked permission as co-guardians to place my mom at Stone Valley Alzheimer's facility. And there was an order put in place that my mom, by court order, could be placed at Stone Valley. And
she subsequently was?
And she was in June of 2016.
And per that order, there was visitation permitted or outlined.
Part of the reason the judge approved the placement of Stone Valley is because it would allow my mom to visit both of her children. That was a place that both children could come to see her.
And the court order outlined that you got either even or odd days and your brother got the opposite.
Right.
and there she was to remain.
Right.
This is an Alzheimer's care, or she's put.
Your Honor, objection, leading question.
I don't think Mr. Stiggy finished the question.
What was your mother's sort of capacity, mental capacity, and ability to care for herself at the time, or leading up to her placement at Stone Valley?
My mom's capacity with Alzheimer's just was continually declining. So at the time, she was placed at Stone Valley in 2016. At that point, she was already incapacitated and described that way by the doctor.
I'm going to object to that being hearsay, Your Honor, for the purposes of this hearing.
Mr. Stiggy.
I'll ask it a different way.
Alright.
Did the court adopt any findings of any doctors in permitting the placement of your mother into the home?
Yes, my mom had a brain scan and she had a medical diagnosis.
Your Honor, objection, that's non-responsive. It was asked what was placed in the order, not what doctors did.
No, it was asked what the court findings were in relation to the doctor.
That is correct, and that's why it's non-responsive.
I will allow the answer.
My mom had been diagnosed by a neurologist having Alzheimer's, and she had a diagnosis, and that information was addressed in the courts about her medical condition with Alzheimer's, and which was continually declining.
And did that, leading up to her placement, did her medical condition affect her ability to do day-to-day activities, sort of care for herself, things like that?
Yes, she couldn't be left alone. She needed constant care and supervision.
And were those findings placed before the court, or those issues placed before the court, leading up to the court allowing her to be, or placing her there?
Yes, before the court made that decision, we had a Dr. Rubin come out and do evaluation of my mother. We also had Creative Elder Solutions, I think, come out and talk about and do an evaluation of what her day-to-day needs were, as well as she had a neurologist, Dr. Spivak. So there was a lot of medical evaluations done before the courts approved my mom to be placed in Stone Valley.
And your mother's age around this time was she?
I think she was, at the time of placement, she was 76 or 77.
Older than 60 years old?
Yes.
Okay. So let's go, moving forward, once your mother is placed there, this visitation, if you do know if Roger visited your mother at Stone Valley.
Objection calls for hearsay response unless she was personally there.
Well, it's not hearsay if it's a statement of a party opponent. It's also not hearsay if it's within her personal knowledge.
Steve, the question I believe is being asked about her knowledge. I think she can answer about her knowledge.
I visited my mom as frequently as I could, multiple times a week. I tried to get up there daily or every other day. So I was always made aware.
Objection, hearsay.
Frequently, the...
Hold on, ma'am. Let's address the objection.
Okay.
That's all right. Mr. Jacob?
The court just allowed her to testify to personal knowledge or sort of her understanding of the situation.
I agree. I think she can testify as to what she was aware.
Well, look who's here. First of all, thank you, Paul, and you got me with probate nerd. Deborah Davis.
Tardy to the party like usual, but I'm
This
here.
is attorney Sue Kelleher. She's my probate guru. I've told you about her.
Yes, I have heard. I'm
Debbie.
excited. Hey, I'd love to connect because I do have clients that kind of cross states here, and it's nice to meet you.
I think nice to meet you too.
Yeah, this is awesome. Two of my favorite ladies, despite the fact that they're attorneys.
Yes. We just
Who
love
knew?
lawyering on Saturdays. It's so fun.
Well, we're going through this, and it really is a probate situation. This is Hillygus's sister getting on the stand, and she's kind of been laying out what's going on. And I don't see, I don't know, you tell me, Sue, I don't see anything where Roger Hillygus has authority to
No.
yank her out of a home.
Now, one of the things she said at the beginning of this clip was that she had a court order to even move mom into the nursing home. So you don't move mom without a court order. That's number one.
And she actually was the guardian.
Yeah, and she actually was the guardian. So she can't even move mom without a court order. And then by the time he takes her out, mom's in a very declined state. She should not be without medical care at that point. So not only is it a no-no in the court's eyes, it's a huge detriment to mom's health and safety. So bad all the way around.
Yeah, you know what? Since I stopped it too, this came up in the last one. He kept saying that he had a jury verdict, and again, I think it's sovereign citizen nonsense where they have a fake court or whatever. But it brought up the issue. He said I have a verdict to be administrator or guardian or something. I don't know, because he was making it up, so he probably wasn't using the right terminology anyway. But you handle all my stuff. We've known each other for years. I've never heard of a jury in probate. Are you guys doing juries over in probate?
You usually, at least where I am, we usually have a bench, but it could be different where they are. So we just would have a judge making a ruling on that. It could be jury over there in Nevada. I'm not sure. But
I mean, because I'm always doing, like a wrongful death case where we're opening estate or a minor's estate or a guardianship for somebody who, like in the nursing home context or something like that. I've not seen a jury. I mean, I'm not doing it. You're doing it, but
yeah, we don't do that in Illinois. We don't have juries on guardianships. But
do you do that over there, Deborah, in Michigan?
I'm not sure if we do them on guardianships, but probate does have certain jury trials that they have. So I don't know. I'd have to look into that. But I was listening on my drive over. So I am kind of caught up on what you guys have been listening to. And I will say this witness is very well spoken. Mm-hmm. She clearly knows her stuff. She's prepared. And hearing what I heard on the other witnesses, this plays very well for the prosecution to have her up there knowing what she's doing. I did have a question though, Suzanne, like with court orders in Michigan, generally, once you are ordered by the court as the guardian, you don't have to go back to court to move her anywhere. If you want to move her home, you move her to the care facility. Basically, the court gives you the permission to do whatever it is that you think is best for her. And if somebody disagrees, like a brother that you're not getting along with or something, that brother can bring it to the attention of the court with a petition to modify the guardianship or whatever. But generally, as long as the guardianship is in place, the guardian can move the person wherever they think is best.
Mm-hmm. We do it a little bit differently in Illinois. In each county is even different. If you're in Cook County, which is Chicago, the rules are much tighter than the outlying counties. But the rule for us is any move is supposed to be approved before it happens. Okay. You don't see that very often because a lot of times a move is an emergency type thing. Mom has to move to a nursing home or something like that, and we can't keep her until a court date. So it'll happen that the move happens first. Most often, if it's a lateral move, we're moving from house to house. That doesn't even end up in front of the judge. But a lot of times it's important to or necessary to bring it if she's going to a facility. That's always a must to get that approved.
The other thing that struck me as different, and maybe it's just a Nevada thing, they're kind of intermingling the trustee and the guardian and okay, mom named this person as this and this person as that. For us, if you have a trust, there's your trust document. And then over and above that is a medical power of attorney, which is, the way that you name a person to say, I want this person to take care of my care decisions if I'm incapacitated.
Mhm.
Obviously, mom is now incapacitated. She can't make her care decisions. If she had that medical power of attorney, it would substitute for a guardianship. And you do have the legal remedy in Michigan if you don't think that that person that's named by mom before she was incapacitated is doing a decent job. You can petition to have a guardianship like that would override your medical power of attorney.
Mhm.
But for this one, I'm not getting if it was something where sister thought brother wasn't doing a good job, so that's why she petitioned to have him removed, or what happened. So I don't know if Mike or either of you, if you know a little more background on that.
I don't
I
think we
don't, but
know.
I feel compelled to tell everybody because everybody here knows you, Debbie, as the prosecutor, and I just happen to know you because I know because we've had chats. She's done a bunch of probate stuff in Michigan. Number one, number two, I think your father-in-law is a judge and does the probate division in St. Joseph County.
Yeah, so my father-in-law is the probate judge, and prior to him being elected, I did a fair amount of probate work, and I still do on the side. We have estates and some adoption.
I just thought I'd explain to everyone why you're getting knee-deep in probate.
I know about probate, lady. Like, yeah, I know.
Meanwhile, while both you guys are talking, I'm glazing over because when I get these issues, and I send them over to Sue, and then I mess them up if I'm involved. In fact, we're to the point now where Sue knows to just talk to Yesenia, my assistant, so that nothing gets ruined.
Right. Like, not interfere with anything. Just let Susan do it.
They just tell me where to go, and then I
Keep
show
it out
up.
of your hands. Yeah, keep it out of your
That's it.
hands. Well, something went on originally that we don't know about. There had to be something that happened. It sounds like mom and dad during their lifetime set up their documents and maybe made Hillygus in charge of everything. Maybe he was trustee. Maybe he was that power of attorney. And then something went wrong that we don't know about because it ended up in the court system and he was pulled out and the sister was made, the guardian and the trustee. So something went wrong with him. We just don't know what it is.
All right.
Well, I imagine sister's going to tell us here soon, right?
Mhm.
Like,
Yeah.
working our way up to it.
Get
So,
to the good stuff. Yeah.
making sure that I wasn't like missing something here. So I'm glad that you guys.
Nope. Yeah, you're up to speed. It sounds like to me.
Okay. All right.
Regarding the situation.
Well, I was aware and informed by Stone Valley a few different times when there would be problems.
Your
So,
Honor, again, it's non-responsive to the amount of the visitation that my client is using. Now it's going into allegations of problems, which are being often for the truth of the matter asserted. I have to object. This is entirely hearsay. She can say whether or not he knew he visited or not, but anything else, I have to continue to object.
Ma'am, if you would just limit your answer to the question that Mr. Stiggy asked, it was regarding the visitation.
what was the question? Am I,
Aware of whether your brother would in fact visit your mother once she was placed in Stone Valley?
there were times, yes, that I was aware he visited her.
And the sort of even odd, was that schedule kept too?
No, he was allowed to visit, anytime he showed up, he was allowed to visit her. They never, enforced the even or odd, and I was fine with that.
Did you ever, from the time she was placed there until the incident in this case, go to visit your mother and see Roger Hillygus there?
Yes,
The
last time that I saw Roger at Stone Valley was in July of 2018, 1 year before the incident.
Okay,
At that point, he was with another man, and they were saying things to my mom that by the court order, he was not supposed to be discussing with my mom.
such as what?
I'm gonna get you out of here, Mom. Robin put you in here, and we're gonna get you out of here. Don't worry, we're gonna get you out of here. You shouldn't be here. This is ridiculous. And those were discussions, none of that was to be discussed in front of my mom.
Do you know who the other person was?
I have a picture of him, but I I think I know the name, but I can't bring it. I can't remember right now.
Okay. Any other time where you would visit or go to visit and you would see your brother there at Stone Valley?
That's the last time that I saw my brother at Stone Valley. I don't believe that he had been there after that visit. But they had to call the police. They asked him.
Your Honor, objection, hearsay.
And ma'am, just, please respond only in answering a question asked from one of the attorneys.
Okay.
There wasn't a question posed. That's all right. I know this is difficult. Go ahead, Mr. Sticky.
And so, do you have, in this sort of the last year, do you have an idea? Do you know how often your brother would visit?
To my knowledge, he hadn't been there once in the last year, from July of 18 to August of 19.
Okay, so that gets to the whole nub of this for me, and I want to throw this by both of you. I'm going through this, and there's a playlist with like 20 some videos. I'm saying this to both of you, and I was going through, but I wasn't looking forward. I was just like doing it as my impression as I go, so I didn't know the whole case. But that didn't work because my law nerds get into my comments and tell me what's coming. Okay. So I'm just wondering this whole time I was trying to keep an open mind, but I'm to the point where I think I want to solve the puzzle. Okay. I think I know what's going on.
Do we each get a chance to give our?
Oh, absolutely.
Should we write it down and then like put it up? No cheating. We'll let you go first.
I'm looking at this going, this guy never had capacity. He made up some soft sit nonsense jury verdict, which has zero influence on anything. And this is where the probate, where you guys know more about stuff. First of all, this is weird to me to see families going at it like this. I mean, I do PI, but you rarely see that. Rarely. But in probate, you see it every day. Mm-hmm. Every freaking day. That's what happens. But I think it just boils down to money, plain and simple. The facility wants her out so they can sell the house and pay their own bills with it. And he wants her out of the facility so that they don't drain her assets. I don't think this case is any more complicated than that. Ultimately, it's a kidnapping, but that is the motive, and that is everything that's going on in this case. Tell me I'm wrong.
Suzanne, you want to go next?
Sure. I mean, that's my assessment too. He's living in the house. He's been living in the house for a few years since his sister became the guardian, and he doesn't want to have to move out of the house. He doesn't want to lose access to everything he's had. And the only way he gets to keep that is if mom lives there with him. He doesn't have any rights to it, but he doesn't want to move out. Bring mom home.
All right. I get to be the devil's advocate here.
Uh-oh.
So I don't completely disagree with either of you. I believe it's monetarily motivated, at least in part. And clearly there's not a good relationship between brother and sister. Not sure why, if it's just on this or if it's something prior. But when mom named them co-trustees and co-guardians, there's no way in hell that they were in a poor relationship between siblings when mom did that. Because mom wouldn't have done that if they didn't get along. Are you agreeing with me, Susan? When somebody comes in and does their estate planning, like, I want to do co-guardians and co-trustees with my kids. Mm-hmm. Like, are you sure?
Yeah.
So either something fell apart later, or mom was worried that one was going to screw the other out of money if she didn't put them as co-guardians. Okay, so I guess that's an option. But knowing how care facilities can be, and having a parent that lived with you, so if you're on like defendant's side, and mom lived with me, if there was no neglect or abuse of her going on, having her, or if there's no like safety issue, true safety issue, living in your own home is, in my opinion, and most of my clients' opinions, more ideal than being in a care facility. Less chance of illness from the other people that are coming in and out. Mm-hmm. You get to see your family whenever they want to stop by. it's more comfortable for the family to stop by. Some people just won't go to a care facility. They don't like to see and hear and the smell what goes into that. I don't know what kind of care facility she was in, but there's like top to bottom of very different levels of nursing homes and assisted livings. So if we're looking at his feelings, for whatever reason, he got booted off from being able to make the decisions. But I think, and this is coming from me listening to you when I was driving to Hillsdale basketball game the other night too, I think they're setting up a defense of others claim here and saying, sister, you don't care how they're treating her there. And I got trespassed from there. So if you're saying, sister, I haven't been there since a year before this incident happened, it's because you got a court order that I'm not allowed to tell mom that I want you to come home and I want you to be where I can care for you and provide proper care for you in a more comfortable environment. And since I broke whatever court order this was to not talk about this and give you this idea during your lucid moments, maybe if she had any, that now you've trespassed me and I can't even see my own mother in this facility. So why wouldn't he, if he truly felt that she was being cared for in a worse way there versus what he could provide at her home, I can see where he would set up a defense of others and say, she can't speak for herself. I need to protect her. Now, that's not the way to do it, though. You got to go to court and get the, probate judge to agree that you can provide a safer, more stable environment. So that's what I'm thinking. And the cost-wise, these are very expensive. And if there's not any money left and you couldn't exclude that house asset from like a Medicaid application, then yeah, that house has got to be sold and spent down. All of her 401k or IRAs or whatever have to be used to pay that care facility. And that's why a lot of families choose to keep their loved one at home as opposed to spending down the assets and putting them in a facility. So there you go. It's my.
I think you just gave the best defense you can for him.
Mm-hmm. Right.
Defense attorney at heart. At
like
some time.
if I'm hired to represent him, that's what I'm saying.
That's all you've got.
Yeah, I mean, like he truly
Yes.
truly honestly believes that he was defending another person, his mother, by doing this. And if they did trespass him from his mother's care facility and he lived with her for a few years prior to her going in, that's kind of mentally abusive, right? Like, I get that he shouldn't be talking about like, you shouldn't be here and I'm going to bring you home. But with dementia patients, like having that person that they know and that consistency in visits, I think is important. So for the facility to say, no, you can't come here, it's like imprisoning.
Yeah, but I was listening to the testimony. It sounds like they had that they had some order in place that he's not supposed to be there, but they weren't enforcing it. That was the testimony I was hearing.
Well, then why would you have? Then it's just petty. Like if sister is getting this order that says you can't come here, but the nurses are like, she keeps asking for her son. She wants to see her son. We're not going to enforce it. Then it's like, sister, you're being petty because the nurses that are seeing this woman every day, and maybe she's crying for her son. And so these are few people that maybe with her dementia, she still kind of remembers. I can see where.
I think we're seeing. I think we're seeing the defense case here right now.
Yeah.
So right now, this is a preliminary hearing. I don't know why they went this nuts with it.
That's like preliminary exams. Like this is way deeper.
I mean, this goes on for days.
Which is, I mean, I know you asked the question the other day, preliminary exams, do they last this long usually? If it's a murder or if it's something very significant, they can. But I would say the longest one that we've had is maybe like 4 or 5 days here. It wasn't one that I was a part of, but back like when I was in defense and there was like some complicated like murder type stuff. But for this should not be this long.
Do you think that has something to do with the sheriff being involved? Somebody who's got some clout in town?
I mean, yeah, I think that sometimes that makes you want to cross your T's and dot your I's a little better to make sure that your testimony is locked in. Yeah, maybe. And sometimes we do a preliminary exam because we're afraid that the witness might pass away if they're in bad health or
Right.
whatever. You want to lock in that testimony, and because it's adversarial right now, like they can cross-examine the witness. If that witness dies after your preliminary exam takes place, their testimony comes in at trial through a transcript. So
Mhm.
it's important, if you're doing a prelim, you better be prepared and ask
Mhm.
the questions that you want to. And so I think with this one, they're like, well, if we're doing the prelim, might as well lock everybody in as tight as we can so that if something happens to one of these witnesses,
I didn't think of that.
Mhm.
Again, because I'm on the civil side, I
Yeah.
didn't think about locking in testimony.
yeah, so it's kind of like your depositions on the civil side, right? Like our
I mean, this is really law nerding out here, but like a
yeah.
deposition, yes, but a discovery deposition doesn't work. You need an evidence deposition in Illinois.
Mhm.
Trust me, I've been down this. I've had the old client that's circling the drain that I want to get their testimony, and I have to do a motion to advance the
That's
trial.
a terrible way to describe that. Oh,
Probate people don't like that saying.
yeah, probably people are
Mike.
I was like, don't you feel so much better that you got your estate planning done? Now nothing's going to happen to you for
Right.
years and years and years. And you're like, my client's circling the drain here. Oh, Mike, come on.
Yeah.
Woo.
Yeah. All right. That was it for the testimony that I'm going to do. This goes on and on and on. But it got me far enough because I want to tell the narrative of this case, and it got me far enough. And I had the like two best people on the planet to explain it. Thank you guys so much.
Thanks.
That was
It
fun,
was
right?
fun.
I appreciate it. Now, both of you are forbidden to be to talk to each other
Why is
because
that?
everyone's trying to dig stories out of Sue because she's
Yeah.
known too long.
I'm
She
going to
doesn't know
start my
anything about this.
own
It's okay.
show. Tune into my new YouTube channel where I will talk about Mike.
We
Oh,
could make like a whole series on Let's Talk About Mike.
Yeah.
oh my God. This seriously, I apologize to all of you because there's an expectation that you won't learn anything when you come here, and this got out of hand for me.
Oh,
But that was a substantive law
That's
discussion by people who actually know something, and I apologize.
fun, right? I think
I
that
won't
people
let it
like
happen again.
that. Much fun. They like it.
Good fun for a Saturday afternoon.
Yeah.
Oh,
Who doesn't
you
want to
guys
talk
are-
probate?
You guys are the best. You're both busy. Your moms, I know. Is Marley there? Is Marley there right now?
She's resting comfortably on the floor.
She's got this sweet little dog that I saw before we came on. All right, I'm gonna let you guys go. Deborah, you were saying something about you're gonna do something live later. Am I supposed to go to that?
So okay, Susan, your friend's gonna judge me, but that's okay because you know what? I am who I am. Our good friends are breeders of pigs, swine, and so they're having their big sale of all of the little piglets, and they're the cutest freaking things ever. And so it's like a big to do. They have this like ring set up, and they have an auctioneer, and they have food, and people walk through the barns and look at all the little pigs, and some of
Sounds
them
pretty
are
cute.
extremely high dollar, and it's just it's a fun event. So I said, Mike, if nothing says Debbie Davis Hillbilly more than live streaming from a hog sale, I don't know what else would. So I have to see if my Wi-Fi is going to be strong enough to do it. Because last night in the barns, it was not great. So I'm going to bring my hotspot.
Okay.
And see if I can make it
Well,
work.
for our purposes, it's plausible. There's a live stream coming from Debbie tonight, and it's
It very
plausible
well
that I show up on it. I don't know.
Because
I owe you now.
I want to hear what your commentary is about hog sales. Like,
Oh,
Are you
I'm just
coming
gonna
home
think
with a new
piglets are
pet?
cute. I can tell you
right,
now.
right. Like, I mean, they're small. I would like pick it up and just take it home with you. They're only like
Very
maybe
tempting.
something.
If only they
I
stayed
got them to-
small.
I want them to breed me a teacup size one, like I've seen. I don't think they really exist in the real world, but if they do, I would love one. So
I think you're sparking an idea. Somebody's hearing this and they're thinking, how do we make the teacup piggy?
I mean, supposedly there are. I don't know.
Mhm.
Is not everything on the interwebs is true. So, but I've seen like pictures of pretty tiny pigs. But the ones that my kids are interested in are still in the little piglet nursery. They're not old enough to be sold yet.
Mm.
So that sale's coming in a couple months. I want to say in May. So I'm already scoping out the ones that I like. There's a little blue-skinned, gray hair nugget, just like a little pork nugget that it was the raunch that they didn't think was going to make
Spoiled
it.
nugget.
It has my name all over it. This is my project. So we'll see. There you go, Susan. You probably,
I love it.
yeah.
All right.
Yep.
Sue, thank you. This is Sue's first
Bye, Margaret.
time. She is now
fun.
officially a YouTuber. She got on this deal.
Officially.
She's like,
Yeah,
wait, is this Zoom? I'm like, close enough.
Like, it's
whatever.
kind of the same thing.
Pretty much like Zoom.
Yeah, kind of the same thing.
All right. Thank you all. I want to wrap this up because I don't want it to get too long. Everyone needs to get on with their weekend. Thank you both so much. And thanks everybody for coming out to Law Talk with Mike, where we talk about probate and pigs. Okay?
Yes.
I
PMP.
love it.
Good night.
Thanks, Mikey.
Bye,
See
guys.
you later. Bye.